Well, back here on planet Earth, the Trump administration is taking on Meta in court today, the social media giant that owns Facebook and Instagram. The Federal Trade Commission will attempt to prove Meta has maintained a monopoly over social networking through its acquisitions of Instagram and WhatsApp. FTC attorneys claim Meta legally acquired the two social media sites as part of a larger strategy to buy or crush up-and-coming rivals. Meanwhile, Meta maintains it simply followed current laws. And that case is being argued in district court. But now let's turn to the U.S. Supreme Court. Well, some of the upcoming cases. And Amy Howe, author of SCOTUS blog, joins us now. Amy, great to see you. First off, I do want to get your take on President Trump. So far, he's filed 11 emergency applications at the U.S. Supreme Court in just the first few months of his second term. Now, some court watchers are warning that these applications could lock the justices into an ending cycle of incomplete rulings. What's your thoughts?
And we certainly have seen the justices so far have not reached the merits, the underlying merits. These cases have all come on, these sort of emergency applications where they are asking the justices to put the lower court's rulings on hold. And in some cases they are, but not ruling on, whether or not the lower courts were right or wrong, or whether or not the Trump administration was necessarily right or wrong, but really acting on procedural grounds. And so at some point, these issues are going to come back to the Supreme Court. And as you say, like they're going to be sort of bouncing back and forth. And the justices could be busy, not just through the late June and early July, which is when they're normally busy, but through the summer as well.
And this year, the High Court is actually continuing its streak of religious decisions with two education cases, one out of Maryland, the other out of Oklahoma. And next week, the case will be heard that will actually allow parents to opt out of material that they say violates their religious beliefs. What are you seeing there?
Yeah, so this is a case about whether or not a group of parents, and there are Muslim parents, Catholic parents, and Ukrainian Orthodox parents, can opt out of having their children exposed to LGBTQ themed storybooks. And so the lower court refused to step in and said, we just don't have it. This case too is coming to the justices, not in an emergency appeal, but in a preliminary posture. And the lower court said, we just don't have enough facts yet in the record to make a decision on the merits of the case yet. But the justices agreed to weigh in. And the challengers are pointing to two different lines of Supreme Court cases. One is the case called Wisconsin versus Yoder, which they say the Supreme Court recognized that parents, have the right to guide the religious future and education of their children. And then another line of cases, they say this program is unconstitutional because it's not what they call neutral and generally applicable. They say that the county in Maryland, Montgomery County, which is in the Washington, D.C. suburbs, has a number of programs like human sexuality in which parents are allowed to opt their children out of the curriculum. And so essentially it's discriminating against these parents, against religion in this particular situation.
Well, I got to tell you, Amy Howe, thank you so much for joining us right now from SCOTUS blog. Thanks again.
Thanks for having me.